Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. As always, I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and we are here with your daily news roundup. All the legal news happening in your world so that you might be better legally informed. We begin today with a new lawsuit coming out of Disney World in relation to a water ride in which a woman apparently had serious injuries leading to serious harm, bleeding, and all kinds of problems. So, she's on this water ride and things happen and she has serious injury. So she is basically claiming negligence against Disney World. So we're going to learn a little bit more about this lawsuit coming out of Disney World. Let's get started with this. Okay. This is in relation to the Humunga Cowbunga. Wow, that's hard to say. This is in relation to the Humunga Cowbunga slide, as pictured here at Walt Disney's Typhoon Lagoon Water Park. To show you what the ride is in question, a woman says that a trip down the water slide at Disney World's theme park ended in injuries serious enough that required surgery. So some pretty serious injuries indeed. Emma McGinnis was at Typhoon Lagoon Water Park, which is part of Disney World in Orlando, in October of 2019 to celebrate her 30th birthday, according to the lawsuit that was filed. While at the park, she decided to take the Humunga Cowbunga water slide. According to Disney, riders take the slide down a 214-foot drop in the dark and then spray their way to a surprise ending. Unfortunately for her, the surprise was significantly painful and required serious surgery. So she apparently suffered this injury as a result of the ride, which sounds a lot like Disney might have a problem if that's true. According to the lawsuit, as Miss McGinnis neared the end of the slide, her body apparently lifted up off the slide. She became airborne and was slammed downward against the slide, which increased the likelihood of her legs becoming uncrossed or otherwise exposing herself to injury. So she became airborne according to according to the suit. And as a result of that, maybe her legs came uncrossed. And as a result, some injury might have occurred. The impact of the slide and the impact of the standing water at the bottom of the slide caused Miss McGinnis's clothing to be painfully forced between her legs and for water to be violently forced inside of her, experiencing immediate and severe pain internally, and blood began rushing up between her legs, which, one would imagine that that's documented, of course, by people who were there, photographs, and presumably some sort of incident report taken by Disney. The claim is going to be basically, for Disney's part, that she didn't follow the instructions. And as a result of that, her injury was her own doing, is going to be the counter. So she argues essentially in so many words, I'm a business invitee. You're required to keep the premises safe for my protection because you have invited me onto the premises and you're required to protect me from hazards. And they're going to argue, we did try to protect you from hazards. We gave you all the warnings. You didn't follow our instructions. So you assume the risk or contributory negligence is basically the dispute in a legal frame. McGinnis was taken by ambulance to a local hospital and eventually moved to a different hospital for repair of gynecological injuries caused by the ride. So they were severe enough to require operation by a specialist, apparently incurring severe and permanent bodily injury, including severe lacerations, a full thickness laceration causing their bowel to protrude through their abdominal wall, and damage to her internal organs. So, this is not just a wedgie. This is pretty serious, right? You've got severe lacerations externally, and apparently there was laceration sufficient to cause their bowels to protrude through the abdominal wall and other damage to the internal organs. When water doesn't compress, as I'm sure many people know. So when you hit water, it is kind of like a wall because it doesn't compress, right? It doesn't become smaller with impact. It just kind of stays the same size. So when you hit it with speed, kind of like hitting a wall. And so, yeah, she got severe injuries as a result of this ride. So something here was wrong. The complaint notes that at the top of the slide, Ms. Guinness assumed the correct position as instructed by Disney to ride the slide, including by crossing her ankles, but that did not eliminate the danger, according to her. Saying, quote, whether the ankles are crossed or not, riding down the slide carries with it specific risks about which Disney knew or in the exercise of reasonable care should have known. Specifically, when a rider of the slide reaches the bottom of the ride and travels into the pool water designed to stop further travel, the force of the water can push loose garments into a person's anatomy, which otherwise might be known as a wedgie. Because of women's anatomy, the risk of this wedgie can produce specific female-related problems because of their anatomy, although it's notable, of course, that the wedgie might produce other specific injuries as it relates to a man. So they both have different anatomies. The nature of their injuries might be different, but there are some unique injuries that would only be true for a woman. But then again, there's some unique injuries only true for a man. So, take half a dozen one, six of the other. The surprise at the end of the attraction posed even a greater danger than just the wedgie. The lawsuit saying, quote, the standing water at the bottom of the slide remains a much greater risk of injury when a rider slams into it at the end of the slide and is brought to a quick stop. In the absence of appropriate swimwear or protective clothing, when a rider impacts the water at the end of the slide, the forward speed of the ride can cause the water to force itself inside the body. Because of particular anatomy, as a consequence of the type of swimwear women frequently wear, the risk of water being forced inside the body is greater than that of men, which I don't take any particular position on whether or not that's true, but that's what they're arguing. They're arguing that because women wear certain kinds of swimwear that perhaps is more revealing, that might create problems, which if that's true, then Disney should be aware of that risk and either warn people specifically of the risk or probably not allow people wearing that kind of swimwear to do the ride altogether, right? If you don't have the right equipment, we can't get you to wear that ride. It's just another condition like being tall enough or the right weight or whatever things are true for the ride design. So if Disney was aware of these risks posed by this kind of swimwear and didn't, either specifically warn people about it or allow people to do it, with no special precautions, Disney might very well be liable as a business. You can't just allow your customer to take advantage of your stuff and then be like, it's not my fault. It might be a little bit your fault if there are risks that are known to you as the proprietor that you're not either mitigating or warning the customer about. So that is what's going on there. The lawsuit notes for their part that McGuinness was wearing a full coverage one-piece swimsuit, but this was not enough to protect her, as is evident from the injury. When water is forced inside a patron's body, it carries the risk of it injuring internal organs and causing great pain because, of course, now the water is being forced into your body under pressure, and that PSI, when it hits, the internal cavities of the body, some body parts might be particularly sensitive to that. McGuinness's complaint notes that Disney ignored the particular risk to women who want to take the ride. It also notes that if she'd been provided protective gear or clothing, she would have worn it, which maybe she would have, maybe she wouldn't have. But if they need to do that to successfully mitigate the risk, if they're like, here, take this and wear this, and they're like, no, I'll be okay, then you have more of an assumption of risk issue. But if you don't warn them about it, if you don't provide them the protective equipment, if you're aware of the risk and allow them to proceed anyway, you have some potential liability issues. They say, according to their lawsuit at least, Disney does not warn women of this increased risk of injury when using the slide, and Miss McGuinness was not warned there was an increased risk of injury because of her gender or because of the clothes that she wore. McGuinness and her husband are suing for an amount of greater than $50,000, alleging negligence and also loss of consortium. So apparently they're not having as much entertaining activity together in marital relations as they once did, or otherwise this has come between them. So relating to all that. So that is the lawsuit that has gotten the press today. Disney, of course, has not immediately responded to Law and Crime's request for comment, but we know it kind of where they're going, right? Assumption of risk. We did warn you, there were signs, we told you about it, or you didn't follow our instructions, or whatever their defenses are. Those kind of defenses are what's going on. They assume the risk by doing it. They didn't follow our instructions. They were negligent in their own right. We did warn them, or whatever the facts may allow for. But that, of course, will all have to be teased out at trial. Let's go ahead and wrap this up. Thus, that brings us to the end of the case of Disney's ride causing severe injuries for a woman, apparently as a result of the water slide's design, as a result of her weight, as a result of her height, as a result of whatever. She apparently became airborne during the ride, and that caused her serious injury when she eventually reached the bottom, including by internal damage to her organs and her own intestines breaching the abdominal wall, among other very serious injuries. And so she is basically saying negligence. So this is kind of a standard case in a lot of ways. This is kind of a little bit paint by numbers in some respects. This is standard responsibility of a business. You're a business invitee. You have invited people into your business for the purpose of engaging in your business. You have a duty to the people who engage in your business. This is well established by law. So you do have a duty to them to warn them of dangers, to prevent dangers, to make sure that they're safe. Obviously you're inviting them into your place of business. You have a responsibility to them. That's well established by law. So that's sort of the idea, right? They, as a business, were aware of these risks, did not warn her of the risks, were negligent in not protecting her against the risks, and so forth and so on. And Disney's response will be, we did warn her, we did provide instruction, she didn't follow our instructions, assumption of risk, there was negligence on her part, and the rest of it. In order to figure out, of course, which of those things are true, this will have to proceed further, but that is basically the background of this case. So we'll see how it all teases out in the end. And for the moment, that brings us to the end of discussion of this case. Change the background and push the button. Yay! Hello, everyone, and welcome to Uncivil Law. Thank you very much, Alan Parker, for the 20 gift memberships. They are extensively appreciated. As always, we do appreciate everyone who helps to support the channel at all times. It really helps the channel in every possible way. And I hope that you're having a wonderful and blessed morning today. Everything is going well in your world. I'd like to thank today's sponsor, wehearyou.com.au. Do you ever just need someone to talk to? Sometimes we have those moments when life gets heavy and we just want to talk it out. But therapy can be expensive, and chatting with friends can come with judgment and expectations. Thus, We Hear You is here to help. They are professional listeners who know the value of a compassionate ear during those challenging moments. Whenever you're feeling stressed, lonely, or just need a good vent, they're ready to hear you out, and it can even help with some advice or guidance if you wish. And today on Civil Law, viewers can get 20% off their first call. To learn more about the service or book your session, simply go to www.wehearyou.com.au/uncivil. The link is in the video description below. And we really appreciate our sponsor for helping us on the channel. So check out their website, wehearyou.com.au. See if it's right for you. And if it is, you get 20% off your first service. So, hey, give it a shot. You might like it. Who knows? It'll be great. I need people to talk to from time to time. I'm sure that you do too. And so that might be a service that might be of value to you. So please check them out. And I hope that it will be something that will be of value to you. Thank you again to our sponsor. All right. Let's do another story. Yeah. Too High Strung says sports have acceptance of risk on the tickets that you agreed to when you attend the game. I will simply note that those warnings have various levels of, various levels of legal force to them, depending on your law. So like you signed a waiver, or you know, on the back of the ticket, it says, you know, by doing this, you assume the risk. Those statements have various levels of legal force in some states. I don't know the law specifically in Florida, but I can tell you that in some states, those statements are not worth the paper they're printed on. Even if you signed a waiver, sometimes, you know, it's a matter of state law, incidentally. Like, what are you allowed to waive or not? And some states are like, no, the customer can't waive this. Screw you. You know, you're a business. You have an obligation to the customer. You can't waive the risk. Screw you. So states take various positions on that. So I will simply note that merely because it says on the ticket, or merely because it says on the waiver, you know, you accept all responsibility, we don't have any responsibility, blah, 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 doesn't necessarily make it true. You might want to consult a lawyer. The legal force of that is sometimes less than what the paper might indicate. Is anyone covering Trump's civil trial today? Is it being filmed? If so, I'll cover it, but because Trump said he might show up. But I don't think they're filming the New York one. Yeah, the law gets fun and interesting all over the place. All right, let's cover a new case. All right. Yeah, Too High Strung says, I heard they print them on tickets in the hope of people thinking they can't sue. Yeah, exactly. It's like, well, the ticket says it. So some people will not even look into it. Right. It's like signs, like like on the back of a truck says, this truck is not responsible for like damage to your windshield. I'm like, I bet you are. I mean, the sign says that the truck's not responsible. I'm like, I bet you are. I bet you are responsible. Or a sign at a parking garage says, we accept no liability if you park here. I'm like, yeah, I don't know about that one. You know, you just magically saying things doesn't necessarily make it true. It might be true. It might not be true. Yeah, the sign says, you know, you assume all risk by parking here. Uh-huh. The sign on the truck says it doesn't have any responsibility for rocks that damage your windshield. Uh-huh. Sure. Tell me another story, right? Tell me another story. Is the fraud trial itself being televised? If not, then I'll press on. If it is, then I'll switch. I'm guessing the answer is no. Trump trial begins. Is it being televised? Also, we have an interview at 1, so I'd have to skip out for that anyway. But I'd cover as much as I can because I already gave my word. I already gave my word that we do the interview. So we'll have to bypass the trial because I'm not going to go back on my word. But let's press on. All right. In a very rare event indeed, a superintendent of a school board has been found criminally guilty in a retaliatory firing of a teacher. You don't see that very often at all. I mean, normally you're talking about civil liability for retaliatory firing, right? We fire the guy for illegal reasons. Normally you're thinking, let's get out the checkbook. In this case, you're thinking, let's talk about jail time. So that's pretty unusual in Virginia. So let's cover this story. Let's learn a little bit more about what the superintendent did with respect to the retaliatory firing of the teacher. Let's get started with this. A Loudoun County jury, which is Northern Virginia, a county I know well, having lived in neighboring Fairfax for 15 years. I know Loudoun County right next door is my neighbor. So I know Loudoun County, and a Loudoun County jury found the former superintendent guilty criminally of unlawfully discharging a teacher who reported being repeatedly groped by a student. So you'll remember Loudoun County as the county in which that student went into the bathroom and was assaulted. And then the Loudoun County School Board's like, that never happened. We don't know what you're talking about. And the father threw the protest in the school board meeting and got arrested and all the rest of it. And then it came out as true that all that actually did happen. And they got owned basically by the whole thing. So that's Loudoun County. So it wasn't just the one student with the sexual assault in the bathroom. Loudoun County also went so far to deny these things were happening by firing a teacher who complained they were being assaulted by a student too, because Loudoun County, I guess, didn't want the bad press. The superintendent faces up to 6 months in jail or a $2,500 fine for the retaliatory firing of Erin Brooks, a former special education teacher who had complained about being touched inappropriately by a student in class. So it's like, I am being sexually assaulted in the class, and the superintendent fired the teacher. So, yeah. The jury, however, also found Ziegler not guilty Friday on a charge of penalizing the teacher for missing work to testify before a special grand jury in a separate assault case at a different school. That would be the one with the student in the bathroom being assaulted. So she left school to testify at work, and they found her not guilty on the charge of penalizing the teacher as a result of that. So they're like, well, they split the difference a little bit. Like, we think they fired her because of her own complaints rather than her testifying in another case. So that's what's going on there. Speak Life Guardian Homestead and Permaculture said, you really should opine on what Trump just claimed about disclaimer in contracts. What did Trump say? I'm obviously not watching whatever Trump just said because I'm doing this. So when you say I should opine about what Trump just claimed, what did he just claim? How would I know? I'm doing something right now. If you want me to opine on something, I need more information, man. The Virginia Attorney General said he was grateful for the jury's verdict, saying, quote, justice has been finally served in Loudoun County. Nearly 2 years ago, Loudoun County Public Schools and the Loudoun County School Board were thrown in the public spotlight for all the wrong reasons. Yeah, that would be the sexual assaults occurring by these so-called transgender students occurring in the bathroom, and we can't let that happen because the message must be made true. So yeah. Yeah, just the arrival to court. Yeah, I'm not covering him just walking into a court building. There's nothing to cover there. One of the casualties of their neglect and mismanagement led to retaliatory firing of a dedicated and caring school teacher. Thank you, Jules Buddha, for the 20 gift memberships. Is extensively appreciated as always. We do really appreciate everyone who supports this channel. Thank you very, very much. The defense attorney, for their part, says that they plan to file a motion to set aside the jury's verdict. According to the Loudoun County News, Ziegler, for their part, is scheduled to be sentenced. They probably won't get any jail time for a first offense, assuming this is a first offense. Yeah, okay. Just seeing if I need to respond to that story. All right, where was I? Okay. Defense attorney Erin Hargan. Defense attorney Erin Hargan said she plans to file a motion to set aside the jury verdict, according to the Loudoun County newspaper. Ziegler is currently scheduled to be sentenced January 4th, although for a 6-month term, probably will not get any jail time for her first offense, or it would be de minimis jail time, probably like a day or two, to be quite honest. But, you know, the fact that there's some sort of justice coming criminally that also helps to warn people against this is, you know, not for nothing. So it's a start. Mr. Brooks, apologize. Miss Brooks said she and her teaching assistant were touched up to 40 times a day on various parts of their body while working at the elementary school, but the district failed to protect her despite the complaints. So this wasn't just, you know, a student behaving inappropriately like once or twice, but apparently 40 times every single day. And the school wasn't taking any measures to stop this. And, you know, they have to protect their employees, but they're not trying to. And then they fired her for complaining. So yeah, her contract was not renewed after she went public by reaching out to Fight for School's executive director, who is a prominent critic of the district, who made a statement on her behalf at the school board meeting. Ms. Brooks, who of course has also filed a civil lawsuit against the superintendent, which, you know, they're claiming qualified immunity for the 40 times a day. We had no reason to believe that was wrong, I'm sure. Says the verdict that she was blown away. Just as a friendly reminder, by the way, qualified immunity is a civil law doctrine, not a criminal law doctrine. So if you're wondering why like qualified immunity didn't come into this case, it's because this case is criminal. So it's not an available theory. So they can still try to claim qualified immunity in the civil case, but they got their criminal conviction. Anyways, Ms. Brooks says it's not just about me. This is about our community. This is about our local government. This is about our country. It's unprecedented what happened here today. Ziegler faces another jury trial in February on charges of making false statements when he said during a June 2021 school board meeting he was unaware of any reports of essays in the school bathroom. He was unaware of any of the graping. He said that, and you know, he had some knowledge of the graping. So yeah, there was all that. The school district landed in the middle of the uproar over parents' rights when Scott Smith was arrested for disorderly conduct at the 2021 school board meeting after his 14-year-old daughter was graped by another student in the school bathroom. The assailant, who was transferred to another high school where he had been assaulting another student. A special grand jury had previously said Ziegler had been informed of the assault, so when he made the statements that he wasn't, he was making a false statement and thus might have broken the law there too. So things are going poorly for Ziegler. Check 1, 2. Okay. Thus, that brings us to the end of the lawsuit for the moment. Apologize. Thus, that brings us to the end of the case for the moment of Scott Ziegler, ex-Loudoun superintendent who was found guilty of retaliatory firing in a criminal case. The civil lawsuits, of course, continue to persist, but unsurprisingly that this happened. Loudoun County, the place where this transgender student went into the bathroom and raped another student, and they tried to sweep it under the rug, and his parent protested at a school board meeting, and they were arrested, and eventually it all came forward that, yeah, it really was true, and the school was trying to cover it all up. So a lot of things going on there in Northern Virginia, in Loudoun County. And I think the only surprising part of it is that Loudoun County actually found the guy guilty, because Loudoun County tends to be a little woke. So, you know, the fact that they actually found the superintendent guilty is kind of a nice change, but that's what happened there. So let's make a note of that. And that, for the moment, brings us to the end of consideration of this case. Change the background and push the button. Yeah. All right, let's cover this one. This will be a nice little lead in for a story we're doing later today. In Ken Paxton, Attorney General of Texas's troubles are not quite over news. The Texas Supreme Court has cleared way for the Paxton whistleblower trial. So you may recall during the impeachment trial, there was much discussion of this civil lawsuit that occurred from people who had been dismissed by the Attorney General's office, saying that they weren't working very hard or weren't very good employees. But they say the real reason they were fired is because they were whistleblowers, which would be a violation of law. So this civil lawsuit had long existed before the impeachment thing went forward, right? It went through trial phase, in which case the trial court said, no, there's a claim here. The whistleblower lawsuit can continue. It went to the Court of Appeals, where the Court of Appeals said, no, there's a claim here. The lawsuit can continue. And then it went to the Supreme Court, and it just kind of stalled there for a long time. At least in part, it seems because of the impeachment trial, the Texas Supreme Court was allowing the political process to continue and put basically the civil lawsuit on abeyance without saying it, because they just didn't take any action. So they didn't formally say, this is being paused in lieu of the impeachment trial, but that's kind of what they did. So with the impeachment trial now being over, they've decided that the lawsuit can continue. So the lawsuit will be allowed to persist its way through court. So let's learn a little bit more about this. Thank you very much, Marcel, for being a member for 4 months. Your continued support is appreciated as always. Thank you very much, KL Burke, for being a member for 6 months. Your support is appreciated. We do appreciate all the uncivilians. Amanda Lay gives 10 Canadian dollars to say, thanks for the great coverage as always, Kurt. Thank you for your support. It is extensively appreciated. And Marcel gives $2, say congrats on getting sponsors. Well deserved. Thank you. I appreciate it. Hopefully they will continue to sponsor us. And if not, hopefully we'll get other sponsors in the future. But it's nice to have some sponsors, to be sure. And we do appreciate all your support. The whistleblower lawsuit against the Attorney General Ken Paxton can move forward. The Texas Supreme Court ruling on Friday, setting the stage for Republicans to face the allegations that spurred the impeachment. So the impeachment, of course, itself is a political process and not strictly speaking a legal process. So now that with the political process is over, now we can go back to the legal process because, if it's true that Paxton fired them because they're whistleblowers, that's illegal, and they deserve to have compensation as a result of that. The court rejected Paxton's request to review the case and tossed the case, which has been on pause since Paxton had agreed to a tentative $3.3 million settlement with 4 former aides who had accused him of accepting bribes and abusing power of office. The agreement withered when the Texas House refused to fund it with taxpayer dollars and instead launched the impeachment proceedings. So part of the reason the lawsuit was paused was because there had been a tentative settlement, but there's no settlement because the House refused to fund it because it's political, right? So because there's no settlement, then the lawsuit continues, right? I thought we had an agreement, but there's no agreement. If there's no agreement to settle, then the lawsuit persists. So now we're just back to going to the lawsuit again. So the case reopens. The whistleblowers had asked the case to resume the case after the state Senate, of course, for its part, acquitted Paxton of the impeachment charges in the political context. The whistleblower saying, quote, "We're looking forward to obtaining a trial setting and preparing the case as soon as possible," the attorneys said for the whistleblower said. If the case does ultimately go to trial, which at this case time seems more likely, now that we fought over the issue of can we sue, and the answer being yes, we can. The trial court said yes, you can sue. The appeal court said yes, you can sue. The Supreme Court of Texas refuses to speak to the question, so the answer is yes, you can sue. So there seems like it's going forward. Paxton, his wife, and other witnesses who did not testify at the impeachment trial could be forced to do so in court, which seems probably very likely because, there's no obvious criminal element to this. This is purely civil. So it's not even clear that any of these people could plead the fifth with the right questions, right, relating to this cause of action. So if the questions are sufficiently constrained, it appears that Paxton and his wife may be forced to testify. Representatives for Paxton, who won a third term as the Attorney General in 2022, did not immediately respond to requests for comment. The Attorney General's office had retained a private law firm to help handle his case, and Paxton previously defended the settlement as a way to save money on legal costs, but that is going forward. Because the Supreme Court has denied Paxton's request for review, a lower court ruling that former aides are entitled to sue, of course, stands. So yeah, without the Supreme Court taking the case, which they're under, of course, no obligation to do, because they're a court of discretionary review, so they just say, okay, we're not taking the case, so of course the lower court decision stands. Paxton's attorneys, for their part, had tried arguing the Attorney General is an elected official and thus not a public employee, so the whistleblower law doesn't apply to him, which for my part, I don't think made any sense. I mean, I suppose you're welcome to try, and they did try, but that's not how the whistleblower statute was written. The fact that they're elected doesn't preclude them from being a public employee. You know, I at least the way that I read the law. So that argument didn't make much sense to me. It didn't make much sense to the trial court, and didn't make much sense to the Court of Appeals either, given the way the whistleblower statute was written. So there's like, okay, you can't, I'm not subject to whistleblower law. It's like, yes, you really are. Lawyers for the governor and lieutenant governor filed amicus briefs encouraging the Supreme Court to review the appeal, not necessarily because they endorsed the argument, but because the case dealt with powers of a state official, which, you know, yeah, but, you know, the law can constrain state officials because, well, obviously, right? The fact that you're elected doesn't necessarily imply what you have the power to do. Lots of people are elected to lots of different offices. The constraints on those offices are provided by law. And so the idea that the law would apply to dog catcher, which I'm not sure if they elect those, but, you know, in principle, if the law that would apply to dog catcher also applies to the Attorney General is not exactly frivolous. It seems right. You know, everyone works for the state. You're a government employee. You were elected and everything, but still you're responsible to follow the law. So yeah, that makes sense. The former aides sued Paxton back in 2020, alleging they were fired in retaliation for reporting the Attorney General to law enforcement. They accused the Attorney General also of misusing state resources to help an Austin real estate tycoon named Nate Paul, a friend and campaign donor. Which, you know, that's not necessarily the root of the issue here. The issue is whether they provided the report in good faith, which, based on the evidence that was provided in the impeachment trial, I am strongly inclined to say they did, right? They might have been wrong, but being wrong is not the same thing as being in good faith. You can make a lot of reports in good faith, you know. To give a trivial example, let's say that you see smoke coming from a business and you call the fire department. But it's a barbecue joint, and, you know, smoke always comes from that business because it's from their smoker. But you didn't see that from your point of view. You know, you just saw smoke billowing out behind a building, and so you called 911. You know, you're a good faith reporter. You know, I see smoke coming out from behind a building. I think the building's on fire. Would be a perfectly reasonable conclusion for you to draw. Based on your own observations, did you have any evidence of this? Yes, I did. I observed it with my own eyes. I saw the smoke coming from behind the building, billowing. You know, I was concerned about the fire. So, you know, your own observations can be evidence. I don't know why people keep missing this point, because they're like, they don't have any evidence. They really, really do, because testimony is evidence, I'm quite sure, in the rules of evidence. So things they observed, heard, saw, yeah. Did it give them a good faith basis to believe things? Yeah, I think so. Were they wrong? Maybe. But were they good faith? Yes. And did they retaliate against them? I think the evidence supports that proposition. So I expect them to win their civil case. Their testimony was central to the House prosecutor's impeachment case. Yeah, I thought it was by far and away the best cause of action against Paxton. But of course, when it comes to the impeachment process, as I keep trying to remind people, the entire thing is political, not legal. So the fact that the Senate refused to convict, I don't think is necessarily indicative of anything when it comes to the law, because it's not legal, it's political. So they made a political decision, which isn't to say that it's invalid. It's not invalid. It is a political decision. That's in the nature of the thing. They're political. And they made the political decision that they like the Attorney General, which is a perfectly valid political decision. But it doesn't speak to the law. The former deputy attorney, Blake Brickman, says, for us, this case has always been more about money, more than money. It's about truth. It's about justice. And though political pressure may have thwarted justice this month, we'll continue our fight. Which, yeah, but then again, it's political. So political pressure is not invalid in that sense. Like political pressure in the judicial process is invalid. Political process in the political process, well, that's arguably exactly what's supposed to happen. So one is corruption and one is not. So was political pressure brought to bear? Yeah, probably. Does that mean it's illegitimate? No, because it's political, right? When it's political, political things make it okay. Paxton has been accused of interfering in a charity civil lawsuit against Nate Paul, helping him avoid foreclosures on valuable properties, and investigating federal officials who are looking into Paul's alleged criminal activity. We've covered all that, of course, extensively. In exchange, prosecutors said that Paul provided a remodel of Paxton's Austin home, to which the evidence at best was deeply ambiguous, and employing a woman with whom Paxton was having an extramarital affair, to which the evidence was essentially non-existent during the impeachment trial. So those exchanges were weak, which might have been one of the reasons, incidentally, they convicted, because they couldn't find the quid pro quo, and I don't necessarily blame them. Although quid pro quo, of course, isn't necessarily required for Paxton to be liable under the whistleblower statute, but it might have been the reason the Senate made the decision it did, but I digress. Nate Paul has been indicted by a federal grand jury as well on 8 felony counts of making false statements to lenders in relation to his financial dealings, and has pled not guilty. Let me redo that paragraph. Excuse me. Okay. Nate Paul, for his part, was indicted by a federal grand jury earlier this year on 8 felony counts of making false statements to various lenders. He, of course, has pled not guilty. So Nate Paul, as the real estate developer behind it all, in no sense out of the woods for his part either, as he faces indictments essentially for fraud as it relates to various business dealings by the feds. So things are not looking really promising for him. Let's wrap this up. Thus, that brings us to the end of the story for the moment about the Attorney General's lawsuit going forward on the whole whistleblower investigation. There had been a tentative settlement, but the House refused to fund it, and so the settlement fell apart because there was no consideration, right? In order to have a valid contract, and settlements are just a contract, right? You have to have consideration on both sides, right? They say, we agree to give up our lawsuit. You agree to give us $3.3 million. Well, there was no $3.3 million. So the settlement falls apart because the contract falls apart for want of consideration. There's no consideration. So the lawsuit goes forward. So this will go back to trial level, having determined that Paxton can be sued. We're going back into discovery, which will probably include interrogatories and depositions of Paxton and his wife and other people. And the lawsuit will persist probably for quite some time, I would imagine. But that is what's happening in Texas, and that for the moment brings us end of discussion of this case. Change the background and push the button. Push the button. Push the button. Yeah. Sandy gifts 20 gift memberships, incredibly generous. Thank you very much, Sandy, for your thoughtful contribution, as well as being a wonderful mod who mostly keeps me in line. And thank you, Sandy, for being a member for 12 months. Sandy, hit that beautiful, beautiful join button. You too can hit the beautiful, beautiful join button. And if you don't see the beautiful, beautiful join button, then you can hit the one provided for by the link. For a mere 99 cents, you too can become an uncivilian and help to support the channel financially. Your support is extensively appreciated. Fantastic. All right, let's cover another one. All right, let's do this story. For today's story, we're going to take a look at First Amendment law as it relates to the US Supreme Court and how the justices think about it, in particular attention to how Justice Alito looks at First Amendment questions based on the decisions that he's made. So the First Amendment, of course, is a huge deal. Every single term for the Supreme Court, there's usually a couple cases, 3, 4, 5 First Amendment cases, sometimes more. There's a big First Amendment case this term in particular. They decided to hear this case, net choice versus Florida versus Texas, when it comes to can the states require the social media to host viewpoint neutral content? In other words, can they force them to host content from Republicans or conservatives that the social media companies might not like? And I've covered this case already extensively. I think the answer is probably yes, they can. The states can do this, but of course, it raises substantial First Amendment questions. That much cannot be denied. So we're going to take a look at this article and how the justices think about the First Amendment as we consider these questions coming up this term. Let's get started with this. One of America's great First Amendment statements is that the Constitution protects the principle of free thought, not free for those who agree with us, but freedom for the thought that we hate. Which, the First Amendment really only has value to the extent the First Amendment protects speech you don't like. You don't need the First Amendment to protect speech you like because you like it, right? You have no reason to object to speech that you agree with. So the law doesn't need to protect speech that everyone likes. The First Amendment only has value to the extent that speech we don't like, and arguably has the most value for speech that we even hate. So that much is very true. That observation came from Justice Oliver Wendell Holmes in his dissent in a case called U.S. versus Schwimmer. A subtle, more sweeping variation, you might call anything goes theory of the First Amendment, is that any limit on speech opens the door to broad censorship, and therefore, if the courts protect speech that have no obvious value, we become confident of the vigilance against limiting speech that really matters. Which, that makes sense. It's the camel's nose under the tent problem. Once you let it in a little bit, it's going to get itself further and further and further, particularly in the US system with common law principles, right? Once you let the first exception, the next exception becomes easier and easier and easier, and it erodes. So it's not, so much as a fallacy of the slippery slope as kind of how the judicial system works. Bricks built on bricks, baby. And where you lay that brick down, the next brick will be laid on top of it, because that's just the nature of the system. First Amendment lawyer Floyd Abrams appealed to that logic in a 2010 interview with the Journal. Amidst the left denunciation of Citizens United, he described his effort to persuade the American Civil Liberties Union to continue opposing restraints on campaign speech. Yeah, the campaign speech is the most important speech. It's right at the top of the hierarchy, because the most important speech is political speech, because it's in the nature of what the First Amendment's designed to protect. First Amendment for movies is nice and all. First Amendment for, just entertainment is nice and all. First Amendment for jokes is nice and all. But the most valuable First Amendment speech is the political, because, it's the speech the government would probably most like to limit, is the political, because, the government probably doesn't want you to say mean things about the government. So it is the most important speech because it goes to the nature of the fundamental aspect of democracy. So he's like, hey, ACLU, maybe you should like the political speech. The lawyer saying to the ACLU, quote, "I said to them, look, you bring cases, such as one to strike down a law in which Congress was aimed at virtual child, picture stuff. Not real children being filmed, but otherwise would be violative of the law. I said, you didn't do it because you wanted to protect folks who like to watch the images of children. You did it because you thought the government shouldn't be trusted to make content decisions about who watches anything." Which, fair enough. You shouldn't make decisions. In this particular situation, there are no actual children. So that is, part of the issue, right? So now you're restricting the speech merely because of its content and its salacious nature, which maybe it is very, very salacious indeed. But the classic argument against it kind of falls apart because, no actual children were harmed in the making of this video. So they're like, well, this law that seeks to ban the simulated images should not stand because the logic falls apart. And that was what he said. And he said, well, the ACLU took that position because they thought it was correct, which, fair enough. If any recent member of the Supreme Court followed the anything goes theory, it was Anthony Kennedy, who Mr. Abrams described as all by himself on the court as the single most protective jurist of the First Amendment rights. Incidentally, I'm not sure I agree with that. Whatever can be said about Chief Justice Roberts, and many things can be said about Chief Justice Roberts. Chief Justice Roberts has been very good on a First Amendment law. So I'm not necessarily sure I agree that Kennedy was necessarily the most protective, although, as noted here, Kennedy was the author of both Citizens United and Ashcroft versus Free Speech Coalition, the other case to which Mr. Abrams referred, the virtual images of the children case. That's Ashcroft, if you want to go read it. Justice Samuel Alito, by contrast, vigorously rejects the anything go theory. The First Amendment was not intended to prohibit any regulation speech, he said in an interview. On occasion, that view has left him alone in dissent on free speech claims. So Justice Alito takes a more narrow construction of the First Amendment. However, in practice, there has not been much disagreement between Justice Alito and the rest of the court on most cases. For example, he accepted Mattel versus Tam in dictum in a Holmes case in which he held the court had violated the band's constitutional right for denying trademark application for a racially insensitive name. So that was the band The Slants. The band The Slants was composed of Asian performers. The United States Patent and Trademark Office rejected the application for a trademark, saying slants was derogatory name for Asians because, the sort of stereotype is they have slanty eyes. And so it was derogatory and insulting. And the band is like, wait a second, but we are Asian and we want the name. And the Supreme Court said, I think quite correctly, that the government can't make the determination, at least for the very practical reason, they literally can't. Because as was discussed in the case quite extensively, when it came to issues dealing with insulting or derogatory names, the Patent and Trademark Office, was a bit all over the map on such cases. And there was no particular rhyme or reason, and you couldn't quite figure out sometimes why it made the decision it made. So it was both a problem of logic and also a problem of consistency, because even assuming that you had the right to, you literally can't do it. And your decisions just wind up becoming arbitrary and capricious, which of course the Supreme Court doesn't allow the federal government to do. You can't be arbitrary and capricious. In oral arguments, Justice Alito has a knack for posing scenarios that reveal the untenability of restrictions. So that's one of the things that you want to do when you're, thinking about such things, is you think through various scenarios to see whether or not you have a logically consistent view. And if you don't have a logically consistent view, as for example, the United States government did not when it came to the derogatory band names, their views were all over the map. You couldn't define the rule. And if you can't define the rule, you're going to make Justice Alito upset. And also, for that matter, make me upset, because I'm a rule-based guy. If you can't define the rule, then I have real problems with it. In Minnesota Voters Alliance versus Mansky, the court reviewed a statute that banned political attire at polling places. So it's like, okay, we don't want political speech specifically at the polling place. People should be allowed to vote in peace. Okay, let's give that a shot. Justice Alito therefore asked the question, would an NRA t-shirt be permitted? Could someone wear a shirt from the NRA? No, the state lawyer said. All right, how about a shirt with the text of the Second Amendment? I think that would be viewed as political, they said. Okay, how about a t-shirt with the text of the First Amendment? The lawyer said that would be okay, but couldn't explain why, and thus lost the case. See, this is the problem, right? If you can't define the rule in a way that makes sense, you're going to lose your case at the Supreme Court, or at least it's significantly probable, right? You can definitely have some fuzziness around the edges, because it's hard to define perfect rules, So you might wind up in some problems around the edge. But, you know, if you have problems at your core, this is a problem. So the state's lawyers asked, could someone have a shirt with a text of the Second Amendment and wear that to the polling place? No, that's political. Okay, could they have a text of the First Amendment? Yes, that's not political. Okay, why? And he can't answer the question because there's no answer. It doesn't make any sense, right? That doesn't make any sense. Why is one political and one's not? It doesn't make sense. So the case disappears in a puff of its own logic. When the court first heard Citizens United in 2009, Justice Alito asked the question to then Deputy Solicitor General Malcolm Stewart if federal campaign finance laws applied to books, which this is one of those great moments in legal history. If you go back and you go listen to the oral arguments, there's basically a gasp on tape because people can't believe it. Because he's almost forced to take the position, but the position reveals the ridiculousness of it. So it isn't enough to have a consistent position, of course. That's just the bare minimum to have a consistent position. The consistent position also has to make sense. So in Citizens United, they're like, okay, we want to restrict people's campaign speech by restricting the amount of money they can spend on campaign finance speech. Okay, well, what is campaign finance speech, right? Okay, ads on television, that's campaign finance speech. Oh, okay, right? That example makes sense. But what about other examples? What about a candidate who writes a book and times the release of that book with their campaign, which incidentally, of course, has been known to happen, right? People can't write books for the purposes of them being political campaign tools. This is not exactly a surprise to anyone who's paying any attention. That politician writes book basically as political pamphlet should be completely unsurprising. So what if this politician says, okay, I'm writing this book as a political pamphlet, as so many of my colleagues do, and I want to write this book and release it just as it happens to be, right at the campaign. I want to be released right at the heart of campaign season. I want it to be released 2 weeks before the election because I think in my judgment, that's what's going to really work. It'll get the buzz going. It'll be that last minute thing that gets me over the edge. So it's like, I'm going to release the book specifically timed to the election. And I like to spend lots and lots of money to print lots and lots of books. So Justice Alito asks, okay, so does it apply to books? And the Solicitor General says, yes. And everyone gasps a little bit because now we're talking about censorship of books, which gets everyone's attention. So when the Deputy Solicitor General said, yes, books can be restricted too, Justice Alito got to the heart of the matter by saying, the government's position is the First Amendment allows the banning of a book if it's published by a corporation. Re-arguing the case a few months later, then Solicitor General Elena Kagan admitted the government's answer has changed. So they had re-argument on it, but this first argument kind of doomed it, right? So they tried again. Elena Kagan, then Solicitor General, tried to fix it, but it was kind of too little too late and the game was over. However, for all the value Justice Alito has, he does see some limits that perhaps some of his colleagues do not. He has rejected free speech claims when what we're doing or what we're dealing with is speech that has little, if any, value, and there was established and cabin rules for saying that things should not be protected in those cases. He wasn't yet on the court when he decided Free Speech Coalition, but he cites a trilogy of cases in which he dissented on that basis, so he has some problems with some of the decisions of the court. In U.S. v. Stevens, 2009, an 8-1 majority struck down a criminal statute against knowingly selling depictions of animal harm with intention of placing those depictions in interstate commercial speech. So can I sell the pictures of the animals being abused? Is that okay? Can I sell pictures of animals being abused? Justice Alito said no, and said such videos are analogous to the child videos because it entails violent acts in the process of creating the speech. So in the same way that the videos against the children should not be released because children are being harmed, Heath argues that the videos or pictures of the animals being harmed otherwise are of no value, but he was in the sole dissent on that case. In Snyder versus Phelps, also decided 8-1, the justices ruled the First Amendment shielded a fringe religious group from liability for staging a lawful but grotesque protest outside the funeral of a U.S. Marine. Yeah, that would be what is the name of that group? It'll come to me. God damn it. It's Nate Phillips, right? What's his church's name? Westboro Baptist, thank you. In Snyder versus Phelps, also decided 8-1, the justices ruled the First Amendment shielded a fringe religious group from liability for staging a lawful but grotesque protest outside the funeral of a U.S. Marine. So that would be Westboro Baptist, for those of you who remember that group. They like to say, that God kills, gay soldiers and things like that, and these really sort of very offensive things, and they'll go right to a funeral and they'll protest the funeral. Their speech is somewhat vile and very disrespectful, particularly at a time when people are engaged in mourning. So the justices ruled the First Amendment protected the group, but Justice Alito said, I thought this was an example of an established tort of intentional infliction of emotional distress. And, the line on that gets a little bit tricky, right? And sort of that issue. But, his argument that this is intentional infliction, the idea that, you're doing intentionally with the idea to rile them up, and this is the kind of speech that no one should be forced to bear, but it is political in its nature. So the Supreme Court said that kind of speech was lawful, but Justice Alito dissented. In U.S. versus Alvarez, the justices struck down the Stolen Valor Act, which made it a crime to claim falsely to have been awarded any decoration or medal authorized by Congress for the United States. So this is merely claiming, for example, I got the Purple Heart, or I got the Medal of Honor, something like that, right? So it made it a crime merely to make the claim nakedly. It's still illegal to do it for money. It's still illegal to do it for fraud. So you can still be convicted of being a false, wearing false medals and stuff if you're doing it for the purposes of fraud, if you're doing it for the purpose of tricking people, financially. But if you're just doing it because, you like to wear medals and feel bigger about yourself, that was what this law was designed to prevent, right? Merely wearing the award or claiming the award unto itself. The Justice Alito wrote that Alvarez involved speech that was false. You could prove the falsifiability to a scientific and mathematical certainty. Justice Scalia and Clarence Thomas joined the dissent, which said that such claims inflict real harm on actual medical recipients and their family. So that was the idea, but the Supreme Court said, it's not enough to merely make the false claim. You're allowed to lie. You're allowed to lie is basically the fundamental principle. Lies are constitutionally protected. Just naked lies, yeah, you're allowed to lie. As he deliberated over the cases, Justice Alito, for his part, weighed the anything goes approach by saying, quote, I did think at the time of those decisions, my colleagues might have something, he said. If we say that free speech has to prevail even in these outrageous situations, maybe in a later case, when it's involved important speech, they'll hold firm and resist the pressure to give in. But several of his colleagues who backed protections on this speech have also endorsed restrictions on core political speech. So he thinks that, this principle might make sense if it were really a principle, but he thinks that his colleagues aren't actually upholding as a principle. So at the same time, they are willing to say, no, this extreme speech must be permitted. He thinks that his own colleagues are voting to ban core speech. Justice Justice Stephen Breyer and Sonia Sotomayor, for their part, voted to let the Minnesota t-shirt ban at the voting location stand. 4 justices dissented from the pro-free speech holding in Citizens United, and Justice Alito's vote was pivotal. His predecessor, Justice Sandra Day O'Connor, had gone the other way in McConnell versus FEC. Then there is the recent case of 303 Creative versus Linus, in which the Supreme Court held 6-3, the state of Colorado can't compel a website designer to create sites that celebrate gay weddings. A law dissent, Justice Alito said, involved providing public accommodation in the ordinary sense of the word. For example, allowing someone to eat at a restaurant, allowing someone to rent a hotel room, or a sale of off-the-shelf product. But Justice Alito saying those aren't expressive acts, and the woman who operated the company said she didn't discriminate in that way. So like the Bake the Cake case, in Masterpiece Cake, they both said, yeah, we'll provide standard services. We have some off-the-shelf cakes. People are more than welcome to buy those cakes. We have some off-the-shelf services. We'll bake these standard cakes, for anyone who wants them. But what we won't do is design special cakes for the gay wedding. We won't design special websites for the gay wedding. So Justice Alito saying, well, look, this isn't just public accommodation in ordinary sense. This isn't just a restaurant. This is speech. And so, no, you can't compel the speech, which of course makes complete sense to me. Justice Alito noted in the case 303 Creative that the case involved pure speech. So one of the problems, incidentally, as you're trying to apply 303 Creative, even to a case like Masterpiece, is that you're dealing with things that are not pure speech, right? The cake is a cake. It is at its core a cake. The cake may be expressive, but it's a cake. So you're dealing with a mixed thing, right? On the one hand, expression. On the other hand, it's a cake. So sometimes dealing with those problems in a real way gets tricky. Because how do you separate the speech element from the non-speech element? Or even can you? And then you get into all interesting kinds of questions about how the speech element applies in all kinds of domains. For example, can the florist refuse to design bouquets for gay weddings? Can the insert your service of choice here? Can the tailor not make custom wedding suits for a gay wedding? And so forth and so on. So when you have a mix between the creative element and the non-creative element, things can get technically tricky. So one of the things that made 303 Creative such a great case for the Supreme Court is that it's pure speech, right? It's just a website. It's speech. It's speech all the way down, turtles all the way down, so we don't have these complications. So it made it a much more intellectually easy case. The right to speak against same-sex marriage was important enough that Justice Kennedy's majority opinion in Obergefell, which recognized gay marriage, even declared it that, there is a real basis for people to oppose this. Even at the same time that they were declaring gay marriage to be the law of the land, they were saying that people have the right to speak out against it. But the ACLU filed a friend of the court brief in 303 Creative, siding with the state, arguing that it was an incidental burden on the constitutional right, which doesn't really quite make sense in this context. It might make sense in the tailor case, or the person who designs the custom shoes for the wedding, maybe, right? Maybe that's incidental. But this isn't incidental. This isn't speech that's incidental to a utilitarian article like a cake. Even in Masterpiece Cake, you could make the argument that it's an incidental burden. I'm not sure I would personally agree with that in the case of 303 Creative, given the facts, but at least you could make the argument colorably. It would be a sound argument to be like it's incidental. But for ACLU to say 303 is incidental, it's like, no, there is no incidental. This is the core of the thing. It's pure speech. There is no incidental. It's just speech all the way down. So ACLU saying that they decide with the state because this is an incidental burden is such a betrayal of what the ACLU is supposed to believe in. It's hard to believe, except for the fact the ACLU has been more and more like this in recent years. So the ACLU continues to disappoint me consistently. I wish they would actually do what they said they were going to do on the label. Thus, that brings us to the end of the case. Apologize. Thus, that brings us to the end of the story dealing with Justice Alito and the First Amendment and how he looks at the First Amendment and how he judges it versus his colleagues. So there's all kinds of interesting commentary in this article dealing with how different judges look at the First Amendment in different ways and the extent to which it should protect or not, various things. I tend to take a fairly absolute position, although I wouldn't necessarily describe myself as a hardcore First Amendment absolutist because I have more nuanced views on such things, which I, of course, think are fully within the First Amendment context, which, maybe they are, maybe they're not. But I take a slightly more nuanced view about the thing because we first have to define what the freedom of speech is, something I talk about constantly with my Second Amendment friends. Same thing in the First Amendment domain. We have to talk about what the freedom of speech is before we can even get into whether or not we're infringing on that speech or preventing that speech. But, there's all that. But in any case, this has been an interesting look at how the First Amendment is looked at by the Supreme Court and helps to inform us as to how the Supreme Court might look at some cases this term, including the cases dealing with, can the social media companies be forced to host the political speech from the people they don't like? Can they be forced to do that? I think the answer is probably yes, as how Texas drafted it, but I guess we're going to find out. So we'll see. At least for the moment, that brings us to the end of discussion of this case. Change the background and push the button. Yeah. All right. All right, I'm going to wrap this up a little bit early for two reasons. First of all, I spent all day yesterday editing and I'm a little tired and I need a break. So I'm going to do less, and also that gives me less to edit, which is also nice. So that. And then also, of course, we have an interview with Busby later today, and I want to, make sure that I'm suitably fresh for all that. So we're going to cut this stream a little bit short, but you've had an hour and 15 minutes of uncivil time, and that's plenty. All right. Let's cover Florida Man. Florida Man is more disturbing than fun today, but they can't all be awesome. All right. For today's Florida Man, we turn our attention to a Florida moviegoer who beat up an elderly woman because the woman was sitting in his apparently reserved VIP seat. So the woman was sitting in the seat he was supposed to sit in, and apparently the woman was sitting in his seat, and he decided to respond to this with violence, which seems excessive. There are many other ways to solve that problem, but he decided to respond to it with violence. So, okay, let's learn a little bit more about this. Broward County deputies are currently searching for a man who was caught on camera beating up a 63-year-old for sitting in his seat. The favor to ask the moviegoer to sit in his assigned seat turned out to an all-out brawl in the Florida movie theater, with the incident being caught on camera. The Broward County Sheriff's Office released a cell phone video of the altercation, which captured 27-year-old Jesse Montez Thornton II violently attacking 63-year-old Mark Cohen at the AMC Theater. Okay, guys, there's easier ways to solve this problem. There's easier ways to solve this problem. Ask the guy to move, and if he won't move, alert the staff or something and, get him to move. But the violence is not the way to go, guys. This is not great. Authorities say that Cohen told police that he had bought VIP tickets that included advanced seating for the film for him and his wife. The fun movie date took a quick turn for the worse when he noticed that Thornton and another woman were sitting in his VIP seats. After asking them politely to move, police say that Thornton became hostile. So apparently he asked, and apparently there was some confusion or something, and then he just resulted immediately into physical violence. Video footage of the interaction shows Thornton standing up and getting in Cohen's face, forcing him to step backwards and lose his balance on theater steps. Broward County Sheriff's Office said that Jesse Montez, Thornton II, left the movie theater after attacking the 63-year-old man. Second later, the interaction turns physical, with Thornton standing above Cohen and repeatedly punching him in the face. So, yeah, the Florida man with the aggressive violence. The sheriff's office called the attack callous, saying the victim suffered severe injuries to his head and face and was taken to the hospital for treatment. Authorities say that Thornton and the woman he was with immediately fled the scene. On Thursday, authorities arrested Thornton in Fort Lauderdale after a 2-month-long investigation. And here is his booking photo. So we did find the guy. He faces 1 count of battery with great bodily harm at the moment after attacking the man in the Florida movie theater. Thornton was transferred to jail and faces 1 count of aggravated battery at the moment. And thus, that brings us to the end of Florida Man for the moment. Florida Man, not a fun man today. So that is the end of that story. All right. So again, guys, don't do that. Don't do the thing. Don't do the thing. And all that. So I'm going to sign off for now. I need a little break. We'll be on in 3 hours with our interview with Tony Busby, unless, of course, he needs to reschedule. And if he does, then, we'll do it another time, but currently scheduled for 1 p.m. today. Let me just check to make sure he hasn't canceled on me while we've been talking. All right. No cancellation. So we are, at least at the moment, currently set for 1 p.m. today. Yeah, great. So we will do that. I need to look over some materials and make sure to work on my interview questions. I will see you all later and have a great day. Bye-bye.